Good afternoon, everyone. We'll wait just a few minutes for everybody to join us. Hope everyone's doing well today. Okay, we will get going. So again, good morning, everyone. My name is Josh Stripmatter, and I would like to welcome you to Stripmatter Wealth Smart Money webinar series. Thank you for joining us today. Our presentation today is titled Asset Protection. For those of you that don't know us, we are Stripmatter Wealth Management Group, a registered investment advisor located in downtown Fort Worth, Texas. We specialize in investment management, financial planning, estate planning, and real estate investing. We've been in business since 2007 and serve clients throughout the United States. A little bit of housekeeping before we get started. All of you have access to the chat feature. So if you have any questions, please don't hesitate to type those in, and we will be happy to answer those questions for you. Also, we'll be sending you a replay of today's webinar via email. So if you missed something, don't panic. You will have the ability to watch this again. And you are welcome to forward this presentation and any of our presentations to your friends and family if you think it would be beneficial. Today's webinar is meant to be purely educational and not meant as tax or legal advice. Please talk to your licensed professional before taking any action on any of the information in this presentation. For more information, including key disclosures, please visit our website at stripmatterwealth.com. Now, let me introduce our speaker today. Matt Davidson is from Austin, Texas. He graduated from the University of Texas at Austin with a Bachelor's of Arts in English and went on to attend Regent University School of Law in Virginia Beach, Virginia, where he earned his Juris Doctorate. Following law school, he moved back to his home state, establishing a law practice with his brother James. Davidson Law Group is located in Fort Worth and with a concentration on estate planning, elder law, and probate. So without further ado, let me introduce Matt. Matt, how you doing?
I'm good, Josh. Thank you so much for having me on. I enjoy these things. I'm sure that many of you guys have heard me speak before. I've spoken many times on these about the basics of estate planning, but I'm excited today because we're going to dive a little bit deeper into some niche topics that have been especially relevant recently. And so without further ado, let's hop in. You'll see my slides here. As Josh said, my brother James and I, we run the Davidson Law Group with our focus on estate planning, elder law, and probate. But today specifically, we're going to look at asset protection, anonymity planning, and tax minimization. So let's talk a little bit about asset protection. There's a lot of different perspectives on this. There are certain states that have certain laws that make asset protection easier and better. However, what I try to do is work within the confines of the state of Texas with what our laws are to try and help my clients with asset protection without having to go and move assets to other states or have entities in other states. So let's just first focus on some of the basics. I know that Josh works with many clients with this type of setup, and so do we. But I can't tell you how many people come into my office and they meet with me for wills and trusts, but they have a bunch of rentals out there, whether it be commercial or residential, and they just own them outright in their own name. And that couldn't be worse for them. The liability, if somebody falls and gets hurt, I always use the example of if somebody gets injured bad enough to become a quadriplegic, that's really considered the worst personal injury. They're going to come after your insurance. Over and above the insurance, they're going to come after all of your personal assets. So for rental structure with LLC liability planning, the way that we set it up is we typically have a holding LLC that's typically owned by a trust. And then we have sub LLCs underneath the holding LLC to own all of the rentals. That way you can divvy up your liability over multiple different LLCs. And if somebody falls and gets hurt in one of those LLCs, they can only sue over and above insurance for the value of the property that's in that LLC. They can't break into the other LLCs and they can't break into your personal assets. Now, this is a spot where I usually talk about why I'm not a huge fan of series LLCs. I will do them for some people, but there's just not enough case law out there. So you can talk to Josh or me about that. I'm waiting for there to be some cases where a series holds up and they're protected. But I will do them. They're fine, and 99.9% of the time they'll be fine. But as long as I am able to educate my clients just on the differences between the first structure that I talked about and a series LLC, if they decide to go series, that's fine. But there is just a little bit of caution there. Now, the next protection piece would be asset protection trusts. Now, the laws in the state of Texas don't give a ton of protection for what's called a domestic asset protection trust, or a DAP. So if people truly want to have what would be considered a traditional DAP, they're kind of going to have to go to another state to do that. However, we have come up with a setup here that uses the laws of the state of Texas to do kind of a quasi DAP that is able to protect assets by moving all of these assets into a domestic asset protection trust. Now, the elder law aspect of our firm tells us that the number one creditor for many Americans that they will see will be long-term care. And so when we say asset protection, one of the things that we're trying to protect assets from is the expense of long-term care. So for clients that have this concern and are eligible, we do what are called Medicaid asset protection trusts or Veterans Asset Protection Trust, depending on the situation. And these are basically asset protection trusts that will protect assets from any sort of medical creditors, including having to spin down all the assets before qualifying for any sort of government assistance, whether it be from the state or from the VA, to try and help to pay for long-term care. And then finally, dynasty trusts are something that we're a big fan of. So a dynasty trust has to be given by a third party. So mom and dad can set up their plan in such a way where the inheritance that they're giving their children can be given to them. Instead of just getting a check cut out to their name, it's given to them in a dynasty trust. And a dynasty trust can protect from all sorts of creditors, depending on the situation, from divorces or bankruptcies or lawsuits. And then also, I'm going to talk a lot about the estate tax in a minute, but the dynasty trust can also protect the children from the estate tax at the time that they're passing assets on to the grandchildren. So we think multi-generationally, we think good stewardship, and we believe that asset protection is practicing good stewardship to make sure that you can leave a financial legacy for multiple generations. So the next place that we've been asked a lot about recently is anonymity planning. Big data is quickly growing to be one of the most predatory industries out there. I'm sure that you guys get all those random texts and emails, hey, I want to buy your house, or do you want this or that? And especially after all the events of 2020 and just kind of how the world went crazy for a little bit, a lot of people are wanting more and more privacy, more and more anonymity. And so we utilize a lot of different features here. One of them is for clients who have manager-managed LLCs, or we're setting up manager-managed LLCs. A lot of times we will make the manager a blind management trust, a trust that has your name nowhere on it, and it's named as the manager of the LLC that then holds your real estate. And so this is an awesome tool where you can potentially set it up to where your name is nowhere on a government website, whether it be the Secretary of State, or whether it be a county's deed records, or whether it be an appraisal district. We want to set it up where your name's on nothing on the internet. And this can be exercised by blind management trusts combined with manager-managed LLCs. Now, we often have clients who are conducting lots and lots of real estate transactions, and maybe they don't necessarily want to go with the expansive setup of the blind management trust managing their LLC, or maybe they don't want to close in that type of setup. Maybe they would rather close in a different setup and then move it to that setup. And so for those clients, we've built in a special feature into a lot of our revocable living trusts, and that's a feature called a special trustee for real estate transactions, where clients can actually elect to name Davidson Law Group as the special trustee of their trust for any real estate transactions. So that way, whenever they go to close, they can close in a different setup than an LLC, but their name's not on the warranty deed or the deed of trust or on any of the documents that get filed into the deed records, where oftentimes when there are predatory people trying to go and gather data on what people own, they're going to go to the deed records. And so we can make it where no one would actually know what property you own, whether it be in the appraisal district or in the Secretary of State, or most importantly, the place where everybody forgets is the deed records. Now, for just kind of the everyday client who they don't want to go as far as some of those other anonymity planning features and spend all that money and do all that setup, but they do want some level of anonymity on their everyday life, we have set up just using anonymous names on clients' just basic family trusts. Their basic family trusts that own their bank accounts and their investment accounts and their home. You can't get full anonymity that way and still keep your property tax exemptions and still have a mortgage, but you can have a name that's not your name. Traditionally, people would have put the Davidson Family Trust or the Strip Matter Family Trust, but more and more clients are moving to things just using initials. Like on my trust, I use my children's initials as the name of my trust, so that if somebody went into the deed records or the appraisal district, they wouldn't be able to see my name. They would see these 3 letters. Now, also people do song names, their favorite country song, or just meaningful things to their family. As long as it's not your name, you can accomplish anonymity just with your basic family trust. Now, let's talk about estate taxes and tax minimization as an asset protection feature. So let's start by talking, Josh and I were just talking about it before we hopped on, that as we sit right now, the current estate tax laws are set to sunset and end in 2026 and drop back to what they were before that law went into place. Now, if we could just back up a little bit about the history of the estate tax, if you go back 40 years ago, the amount that you could have when you die before they tax it was down under $500,000. And then they were going to tax anything over that at 40 to 50%. In the 90s, it moved up into the 600,000 range. And so they're going to tax anything that you die with over 600,000 at 40 or 50%. And then George W. Bush came in and said, those numbers just aren't right. We're going to set this law in motion that's going to raise those numbers to be into the millions over the next decade. And that's exactly what happened. And the numbers raised until we ended up in 2018, where the number was 5.5. And then the Trump administration pushed Congress to essentially double that. So then we started with 11 million that you can die with before they tax it at 40%. And it's simply gone up from there under the current law. And so in 2023, you can die with $12.92 million before they tax it at 40%. But in January of 2026, that number is going to drop back. They're going to adjust it for inflation. So it's probably going to end up somewhere in the $6 million number. That's going to affect a lot more people. Now, it won't affect as many people as it did in the 90s, but here's my concern. My concern is that the Congress, especially the further left Democrats in Congress, have kind of already showed their hand about what they would like that number to actually be. So in the Build Back Better bill and in the Inflation Reduction Act, and now even in the budget for 2024, there are certain people in Congress that are pushing for those numbers to go down more towards the $3 million number mark. You can die with $3 million, and then we're going to tax everything over that at 40%. Now, that's when it starts to get scary, because that now comes into the roundabout number that a lot of Americans have. If you add up your home, your investments, your cash, and then a lot of people forget about the life insurance. You add all those things together, and now 3 million number is going to affect a lot more Americans. So we're starting to warn our clients. We're starting to put things in motion to try and get some things in place to anticipate these things. Now, we are blowing our debt just incredibly out of the water. And so right now, it's only far left Democrats that are pushing for these numbers. But I could imagine the next 20 years that if the debt gets bad enough, that we could potentially see bipartisan support for some of those much, much lower numbers as far as how much you can have before they take it when you die. So some of the things that we use to hedge against this is clients can start gifting assets to their children and still control the how much access and control the children can have to the assets, especially if they're young, through irrevocable gifting trusts. And we do these all the time, where clients can either gift the annual exclusion amount to each child, which is $17,000, or they can start to eat into their lifetime gifting amount, which is $12.92 million, and start just getting assets out of their name. I use my family as an example. We have a family ranch. We were able to move the ranch out of our parents' names into my brothers and I names, and then we put it into an LLC and made mom and dad the managers. So for all intents and purposes, it's still theirs, but it's out of their estate for estate tax purposes. Now, another component that we use is what's called an irrevocable life insurance trust. So the idea here is, let's say they make the estate tax exemption $3 million, and let's say a client has $10 million in assets, and then client passes away, and so you would take the exemption away from the 10, so that gives $7 million in taxable assets, and then it's at 40%, so let's just call it $3 million in estate tax then at that point. So what we would have done ahead of time is we could have gone ahead and got a permanent life insurance policy through someone like Josh and put it into an ILIT, or an irrevocable life insurance trust. And the way the ILITs are set up is that insurance money would pass outside of their taxable estate. So then now they get a $3 million tax bill from the IRS, and now the children have liquid cash from this policy that they can use to pay the tax. Now, one thing that I've been doing for clients for a while now, for any client basically over 1.5 million in total net worth, is what's called the Clayton election and utilizing bypass trusts. So the way this works, this can be built into any common revocable living trust that we do for a client, where essentially what happens is when the first spouse passes away, the survivor can elect to earmark a certain amount of money up to the amount of the exemption, which in this year is 12.92 million, to put into a bypass trust that they continue to control, that they still have full control and access over, and they can spend the money if they need to. But the idea is that when the survivor then passes and passes the assets to the children, whatever they put into the bypass trust that they still controlled, and any growth on that money, is not part of their taxable estate for the estate tax purposes. And so this is a very simple solution that makes no difference now, but could potentially make a very big difference upon the passing of the first spouse and then the second spouse. And then I briefly mentioned this earlier, that we do dynasty trusts in almost every will and trust that we do. Instead of just benefiting children outright, we benefit them in a dynasty trust with a limited power of appointment, so that then whenever our children pass away and are leaving money to our grandchildren, anything that we left to them and its growth will not be part of their countable estate for estate tax purposes. Now, just a couple other things I'll mention here. I'm not a CPA, but I work with many of them very closely to do certain other elements for tax minimization. Like, for instance, make sure that if you're married and then the first of you passes away, that you see a CPA and you get them to file for portability. So what portability does is, let's say that my wife passed away in 2023 and we have, let's just call it $3 million in assets, and the exemption's 12.92 million, then there's still another 9-ish million there that was unused by that estate. So then what they would do by electing portability is they could move that 9 million over to the surviving spouse and add it to whatever their exemption is whenever they pass away. So we're in this 12.92 million year. And let's say that then whenever the second spouse passed away, that it was down to 3. And let's say the estate has now jumped up to 10. Then taking the first spouse to die's 9 and adding it to that existing 3 of the survivor, now there's 12 million in exemption and there's no estate tax owed. But that can only be done at the time of the passing of the first spouse. And I make my clients go do it, but that's something that a CPA will do. There's also elements of trying to lower the tax value of certain assets to the IRS. And this is done by certain features within, traditionally it was done in family limited partnerships, and now we're doing it a lot in family LLCs, but putting certain elements into an LLC so that we could tell the IRS, look, this asset is not worth $10 million because it's controlled by 3 different people and you can't really market it on the open market. It's really only worth $7 million. And once again, that's something that a CPA has to guide. But I've drafted these LLCs multiple times with the guidance of a CPA. So see your CPA, but worth mentioning there in tax minimization. So that brings us to a close here, but I just want to say a little bit more about our firm and the way that we operate. We operate on what we call the lifetime planning process. We are not a one and done. We do your documents and we never see you again. We want to make sure that throughout your life, all of your estate planning is working for you. So we've built a few things out to make this more feasible for our clients. First of all, we don't charge for consultations, whether it be the first, second, or the third, or the 100th. We do all consultations for free. And as much as we can, we bill by flat fees. We know that clients like to know exactly what it's going to cost up front. We help our clients fund their LLCs. We help them put their assets into their LLCs or into their trusts. Also, we want to make sure that the family, the next generation, knows exactly what's going on. So we love utilizing family meetings to make sure that when the time comes for the children or the brothers and sisters or the aunts and uncles to act, that they know exactly what to do. And then finally, we built out what's called our client care program, where we can meet with you throughout the year, at least annually, and make sure that everything's working for you. We'll tell you what's changed in the legislature. We'll tell you what's changed in the Congress, and we'll tell you what we think is coming. And so those are some features that we've built out to make sure that your plan is working for you until the moment that it's needed. Josh, I don't know if you want to take questions, but I'm glad to take questions if we're doing that. If not, here's my information here. We do give those free consultations. And so if you have questions that can't get answered here, just call and meet with me.
Absolutely, Matt. Thank you very much. And we will take questions. So if you have any questions, feel free to type those into the chat bar, and I will address those with Matt. In the meantime, I'm going to stop sharing. There you go. And bring up our last slide here. Well, so as I do this, if you have a question, feel free to type it in. And of course, you can call Matt to meet with them. We've referred lots of clients to he and his brother over the years, and they do a great job for us. If you have questions for us, you can schedule a complimentary consultation with us as well. And you can reach us at 817-210-3444, or you can email us at clientservice@stripmatterwealth.com. We have a weekly market update e-newsletter, and you can sign up for that as well on our website, stripmatterwealth.com. And then finally, listen to me on Ask the Experts on Saturdays at 10 a.m. on 1190 a.m., where I answer all of your financial questions. So let me see if we've got any questions here. Matt coming in. I'll ask you a couple questions actually while we wait for other people to type in their questions. This just came up in another meeting, and I wanted to have you just talk about it because it comes up quite often, where we have clients that have IRAs and they want to leave their IRAs to their trusts. You and I have talked about this before, but I want you to give our listeners some insight into that, if you don't mind.
Yeah, absolutely. So there's a few different ways to handle it. First one is if you have minor children, or you have children that are under the age of which you feel comfortable with them having full control over their inheritance, then oftentimes the best way to have those assets held for them would be first by naming your spouse as the primary beneficiary and then naming the trust as the contingent. However, if your children are adults and are over the age of which you feel comfortable with them having control over the asset, because of some of the murky waters that has been created under Secure Act 1.0 and 2.0, and some of the ambiguity regarding the relationship between IRAs and trusts, I often recommend that you go ahead and name those adult children as the contingent beneficiaries rather than the trust. Now, that being said, when the Secure Act passed, we worked very hard with attorneys within our organization to come up with the language that we felt like the IRS wanted in the trust to make it where the beneficiaries of the trust could still get all of the same tax treatment as if they were named as individuals, while the asset is still being held in a fiduciary capacity for minors or for children that are young. And then for some clients that have very, very, very large IRAs that don't want to risk whether or not the IRS is going to take advantage of the ambiguity that was created under the Secure Act. Sometimes we will do what are called standalone retirement plan trusts, where we do one trust for each child that you want to benefit from the trust, from the IRA through the trust. Now, the one thing that I do know that the IRS has told us that could trigger very poor tax treatment for the children is that if you have a charity named somewhere in the trust as a beneficiary, even if it's a contingent beneficiary, if everybody's deceased, the IRS does not like that. And I can think public policy reasons why, because the money was not taxed as income while it was in an IRA. And then if it goes straight to a charity, then it's also not taxed as income. So they never get their money. So I think from a public policy standpoint, it makes sense, but that's the one place where we definitely stay away from. Josh, hope that answers your question. It's a very nuanced aspect of estate planning and definitely something that you should not make a decision on without talking to your professionals.
Absolutely. Yep. I've got one last question. We haven't had anybody type any questions in, but one of the things that we talk about with real estate is owning it in an LLC. And you were talking earlier about having it owned by the trust or having the trust manage an LLC. So what are the pros and cons of having a trust own your real estate versus having an LLC own your real estate?
Well, having just a regular family trust, revocable living trust, own your real estate outright doesn't give you any protection. It puts you in the same boat as if you had just owned it individually. Now, so that's definitely a con. But there's not really any cons of having your trust own your LLC that then owns your real estate, or own your LLC that's a holding company that then owns all the sub LLCs that owns your real estate. That's actually the way that I prefer. And then if you wanted to do the anonymity aspect, then your family trust could own the LLC, and then you could have a management trust being the manager. And that way your manager and your member are two different people, and you're not anywhere on it. So I don't think there's really any cons of doing that setup, except for just attorney's fees and the time and energy to set it up. But you definitely don't want to just own it in your family trust if you have rentals and stuff like that, because it's no different than if you owned it in your individual name.
Perfect. Well, Matt, thank you so much for your time today. We really appreciate it. Great presentation, and I know it was very informative. So we look forward to seeing you on the next presentation.
Absolutely. Thank you for having me, Josh.
You bet. Have a good day.
All right.
Bye-bye.